Good morning, Council. How are you?
Good morning. Very good.
So this is Andrea, Judge Warnell's administrative assistant. I am covering for Diane this morning. I'm just making sure everyone is getting on. And as soon as everyone has been admitted, I will let Judge Halbert know, okay?
Very good.
Thank you.
My name is Kelly Morris, and I'll be the court reporter today. I just want to note that it's very important that everyone stay muted until you're asked to speak or say something in the hearing. Thank you.
Good morning.
Good morning, Your Honor.
Good morning.
Good morning.
Okay, for the purposes of this hearing, this will be held among the attorneys because it involves strictly legal argument at this point, but everybody's welcome, obviously, to listen in. So at this point, the court will call the case Butler versus Shawnee Mission School District, case number 21CV2385. Can I get appearances, please?
Yes, Brant Lau appearing on behalf of the Attorney General's office.
Rachel England appearing on behalf of the Shawnee Mission School District Board of Education.
Okay, Mr. Lau, I believe this is your motion.
Yes, Your Honor. Good morning, and may it please the court. The Attorney General's office has filed a motion to stay pending appeal and for an expeditious ruling to facilitate an appeal of your declaratory judgment ruling concerning the constitutionality of SB 40 directly to the Kansas Supreme Court as the statute requires. We believe that a stay is appropriate under the circumstances because of some of the confusion that has arisen in the wake of the order and the decision. In particular, the court ruled that SB 40 was unenforceable And that has resulted in a number of questions and inquiries to this office and in public in general about several provisions of SB 40 that don't touch upon or relate in any way to the enforcement mechanism that the court focused on in its constitutional ruling. For instance, sections 3 and 13 of SB 40 concern matters that have nothing to do with that enforcement mechanism. In particular, section 3 talks about the composition of the Legislative Coordinating Council, and section 13 concerns certain budgeting appeals and matters. And neither of those touch upon that particular enforcement mechanism. This has the potential to create all sorts of new and novel legal issues that we believe are frankly unnecessary under the circumstances of the case. As you're aware, primary argument of the state in the case was that this case is moot because of the expiration of the emergency previously declared by the governor. That emergency having ended, any future emergency would be a new emergency that in our view is not part of the mechanism under section 1 of SB 40. But for instance, if the governor were to declare some sort of additional emergency in the future, the SB 40 requires that go to the Legislative Coordinating Council. And because of the court's ruling, there is now a serious legal issue about the composition of the Legislative Coordinating Council. So I think that's just one example of the kinds of issues that have been raised in the wake of the order. In addition, there have been inquiries about what is the status of Kansas emergency management law in the wake of the court's decision. What fills the gap, SB 40 having been declared unconstitutional? And there are, of course, a number of arguments that could be made or would be made in any future litigation. But one of the concerns of the Attorney General's office is that the state of Kansas be in a position to respond to emergencies, which by their nature are unanticipated and require quick action. For instance, what if there was an outbreak of hoof and mouth disease in a feedlot in western Kansas in the next several days? Would the state of Kansas be would have a full toolbox to respond to that kind of an emergency, given the nature of the order? We think the best argument would be that you would revert to prior law, but we would expect that there might be arguments from involved parties to the effect that, there is no power to respond to such an emergency. So for those reasons, we believe that the court should stay the effect of the declaratory ruling regarding SB 40 to facilitate a rapid appeal to the Kansas Supreme Court. We have already filed the notice of appeal, and we will soon docket that appeal and brief it with all due speed, so to speak, and get a final ruling on the issues that were initially raised by Your Honor and then ruled in the order that we're seeking to stay. So we would ask that the court grant our motion and stay its declaratory decision on the constitutionality of SB 40, and that the court do so as quickly as it could reasonably do so.
All right, Ms. England. You need to unmute your button, please.
Thank you, Your Honor. The district's objection to the Attorney General's request for a stay, as outlined in our response, is that the stay would detrimentally impact the board and remove the protections against constitutional violations that were identified in this court's order. The Attorney General, in its motion and here today at oral argument, identified a few select provisions of Senate Bill 40 that it thinks should be preserved and kept outside of the court's determination that Senate Bill 40 was unconstitutional. However, what it is asking for is a stay of the entire ruling and in a manner that would harm Shawnee Mission School District and the other government entities that are targets of Senate Bill 40. And so while it's really identified in its motion some narrow relief that it is seeking, which is to have some provisions of Senate Bill 40 severed from the determination that Senate Bill 40 is unconstitutional, what it's asking for is really broad relief, which is the stay of the entire order in a manner that would unfairly harm the school district as the prevailing party. As set forth in our response, the Attorney General could have either identified those specific provisions in its pre-judgment briefing, or it could have filed a motion to amend the judgment and ask for clarification. And that could have been done in a way that doesn't harm the school district and doesn't allow for continued constitutional violations. But it chose not to do that. It's asking for a stay. And we think that that's improper and that it would allow for continued constitutional violations and remove the protections of the court's order. And so one additional point I wanted to add is that the Attorney General's interpretation of Senate Bill 40 is not controlling. We had a school board meeting last night in which epidemiologists from the county came and spoke about the Delta variant and about the increasing hospitalizations and cases and how that variant spreads so much more quickly. There's a real possibility we could have another state of disaster emergency declared. And unfortunately, the Attorney General's interpretation that Senate Bill 40 only applied to the original state of disaster emergency is not controlling. If there was another one declared, we could have litigants file hearing requests and file petitions with the court to try and challenge decisions that boards and other government entities make in an effort to mitigate COVID-19 this fall and winter. And so for those reasons, we request that the Attorney General's motion to stay be denied.
Mr. Lau, here's what the procedure I'm going to do for people who are not lawyers. Typically, the moving party bears the burden, makes their argument, then the responding or opposing party responds, and then the moving party gets a chance to reply to the arguments made by the opposing party. And just for information purposes, once we've completed that process, I will then ask a series of questions myself, and then I will allow both sides to follow up after that. So, Mr. Lau, would you like to respond to Ms. England's comments? And you are muted, Mr. Lau, and I didn't do it.
Very good. A couple of points in response to the Shawnee Mission School District. First of all, they suggest that the state should have filed some sort of other motion, a motion to alter or amend. Of course, it's our view that the defects respectfully in the court's opinion are so overarching that the Kansas Supreme Court is going to have to take a broad view of this case, and that the best response is simply to stay what is only a declaratory decision. Is not, the court didn't enter an injunction enjoining the operation of the law. So our view was that the best way to get this case up in front of the Kansas Supreme Court was simply to stay the declaratory decision below and take it straight on up and do so quickly. So a motion to alter or amend, we thought would have been frankly more burdensome than helpful under the circumstances. Although we certainly recognize that there are, as I articulated earlier, several provisions of the statute which we don't believe could conceivably be unconstitutional even under the court's analysis. Secondarily, to address the effect on the Shawnee Mission School District, it's really difficult for the state to conceive of how a moot statute or a moot issue could somehow affect the Shawnee Mission School District. And we understand that the court took a different view of that issue, but it's our position that Section 1 of SB 40 has expired on its own terms, that any future declarations would be new and separate, and that the remedy provisions that the court found constitutionally offensive would not apply. And in fact, I would expect that if there are new cases filed against the Shawnee Mission School District, you would see the Shawnee Mission School District arguing that those cases are moot and can't go forward on that basis. And we would certainly join in that argument. So I think that the harm here has really been spun out of thin air. There is no real or present harm or danger to the Shawnee Mission School District on the current state of the law. And there would be no effect to them from granting a stay of the court's declaratory ruling. So in conclusion, we would again ask that the court stay its declaratory ruling and allow this case to go forward on a rapid appeal to the Kansas Supreme Court.
All right, I have a question. The motion you filed cites 6262E, which for those who are not familiar with the law is essentially the provision that allows for stays while matters are on appeal. Did you really mean to cite that provision?
I believe we did, yes.
That addresses stays without bond on appeal by the state. And it actually says the court must not require a bond obligation or the security from the appellant when granting a stay on appeal by the state, its officers, or its agencies, or an appeal directed by the Department of State. Doesn't that just apply to monetary judgments? I mean, that's the whole, for the unschooled in the law. If you have a car accident, jury gives you $100,000, the other side wants to appeal for whatever reason. The idea is the party is being harmed if they can't execute on their judgment, and therefore a bond is put up to cover the amount of that judgment plus accruing interest, et cetera. But there's no monetary judgment in this case, so that doesn't even apply, right?
Well, certainly that aspect of a bond requirement, we see in other cases a bond requirement to secure the rights of the appellees on appeal. But I don't think that interferes in any way with the fact that certainly this court has the power to stay its order pending appeal.
Well, you've also said that this is not an injunction, so I didn't grant an injunction. I didn't order the state not to do something. I didn't order the school district. I didn't give it a mandatory injunction. And KSA 6262C deals with injunctions. And you've already said it's not an injunction, right?
Yes, I think on the face of the court's order, it's a declaratory judgment.
Okay, so if it's not an injunction and C doesn't apply, what provision of this rule that you cited actually applies?
Don't have the rule in front of me, Your Honor, but there's a final order that allows an appeal, and courts have inherent authority, even separate from that statute, to enter a stay of their decision pending appeal.
Okay, now in your motion, you didn't cite any case law on that, did you?
I don't have it in front of me. I don't believe we did, but certainly I'd be pleased to provide some supplemental citations if the court feels that it needs them. Okay,
well, the declaratory judgment aspect of this, which is probably more akin to what you're referencing, the court found SB 40 unconstitutional in the particulars that it cited. It did give you the opportunity in the initial order to discuss the issues related to the severability clause, which again, for lay people means typically the legislature, when it passes something, will put a severability clause in to say, look, if anything in this act is found unconstitutional, the rest of it's saved. And I asked you to address that, and then you didn't address it. Is there a reason you didn't address it?
We felt that the arguments concerning the unconstitutionality of the SB 40 were frankly so poor and so overwhelmingly in our favor. And we also felt that the mootness issue, which had to be dealt with initially, and we think the Supreme Court will deal with initially, were so overwhelming that frankly, if the statute was not unconstitutional, there was no need, and we didn't think the court should reach the severability issue.
Okay, so you had the option. You decided that your position was so strong and overwhelming that you didn't need to address it. Is that correct?
I think that's a fair way of stating it. Yes, Your Honor.
Okay. So then when the order actually came out and you were disabused of that notion, you had a post-trial opportunity to ask me specifically to clarify, which I think is fairly plain in the order. And that's called the post-judgment motion to alter or amend. And you have plenty of time to file that. I think it's 28 days. As Ms. England pointed out, that's a post-judgment motion. And you opted not to pursue that, but file a notice of appeal. Is that correct?
In addition to the notice of appeal, of course, as you're aware, we filed the motion to stay for an expedited ruling.
So
yes.
We are at what is called an ephemeral point in appellate law. It's where the district court possesses some authority to control stays while a case is on appeal, but before it's actually docketed, which is something you mentioned earlier, you have not done yet. Is that correct?
That's correct.
All right. So essentially, you had two opportunities to address the very issue that you, and pardon my language, but I think you adopted my language of legal anarchy, which SB 40 actually caused. And you've now said my order that basically restores the constitutional rights of the school district, that is causing legal anarchy, correct?
Yes, we argued that in the motion. We believe that that's correct. That's how I articulated it earlier, for instance, with the example of the Legislative Coordinating Council in Section 3 of SB 40, and then also the budgeting procedures in Section 13.
Okay, so in essence, you would agree the status quo is the Constitution, right?
I can't begin to understand what you mean by that question, Your Honor.
Well, the school district under Article 5, Section 6, or specifically, is given the right by the Constitution to manage and operate school districts. That's the baseline for the constitutional rights of the school district. And that's what SB 40 attacked, correct?
Well, no, we don't believe it attacked it at all. We believe the legislature quite properly exercised its policy judgment to address the emergency of COVID.
Okay, so if I understand correctly, Mr. Lau, because there's no bond required, there's no injunction, essentially you want me to just say, time out, school districts now facing the Delta variant. It's got a question that is now being wrestled with by many health authorities. And you want me to say that somehow my order that simply removed the problem of this case in SB 40 should somehow be put on hold while you litigate this in the Kansas Supreme Court. Is that about right?
Well, in general, Your Honor, I think when you talked about the problem of this case, our review of your orders would seem to indicate that the problem of this case, which is a case between specific plaintiffs and specific defendants, was taken care of about 2 orders ago and was already resolved. So we think there's actually an issue of how the constitutional questions even arose in this case, which we will obviously present at the next level. But we think that given the questions and the confusion that has arisen because of what we view as the overbreadth of the court's order, that yes, that a stay is necessary to abate that confusion while an expedited appeal occurs.
All right, Ms. England, I've had an exchange here with Mr. Lau about some of my questions. You feel entitled to respond.
I think I would just go back to my prior point raised that if your order is stayed, it would open the door for additional constitutional violations to occur, and that given where we are, given the school board meeting we had last night and the evidence or the testimony that we heard from the epidemiologist who attended our meeting and presented a presentation, there is a real possibility that we have another state of disaster emergency declared. And while I appreciate the statement from Mr. Lau that they would provide support in the form of, I guess, I don't know how, intervening in a lawsuit and joining an argument that Senate Bill 40 is moot, your order already interpreted that language and interpreted that given the language in Senate Bill 40, it could and would apply to future state of disaster emergencies. And so we would have absolutely no relief if a state of disaster emergency is declared and we had an individual parent, student, or employee elect to challenge part of our mitigation plan.
Okay. Mr. Lau, any final words?
Yes, Your Honor. When one hears a lawyer argue, as Ms. England just did, about something might happen, or there is a possibility, or there is this future contingency, it's our view that a court should be thinking about concepts like ripeness and mootness and standing. We think that that the potential harm to the state that was just articulated is purely speculative and does not obstruct the court's ability to grant a stay here. So we would urge that the court grant the stay and allow the appeal to go forward.
You just said the harm to the state is purely speculative.
Oh,
and essentially, you've adopted her argument that, you know, if a disaster is declared, if this happens, you know, the LCC and the new membership, et cetera, might somehow impact. So essentially, you're arguing that your arguments are hypothetical, they're speculative, and they have nothing to do with anything that's happening right now.
Well, no, Your Honor. If I said harm to the state, I apologize. I misspoke. Obviously, we're arguing about the potential harm to the Shawnee Mission School District as a basis for granting or not granting the stay.
All right. All right, so you're not taking any position about the actual litigants in this case, about appealing the results of the court's order that found that they essentially didn't have a basis for their claim against the school district.
Our interest is limited to the constitutional issues, except to the extent that we would argue that the case is moot. And I do think that the relative positions of the actual plaintiffs and defendants feeds into the mootness issue.
Okay. All right. So at this point, I actually have prepared an order. I wanted to hear what oral arguments were, and I'm going to issue my order by the end of the day. I appreciate both counsel appearing in this fashion. I will get an order out fairly quickly, and I appreciate both the arguments. Counsel, I'm going to find that we're going to be in recess. Thank you.
Thank you.
Thank you all. Good day.